We are now moving into voluntary winding up. This is governed by Section 439, subsection 1 of the Companies Act 2016, whereby a company may be wound up voluntarily. Okay, when can it happen? When the duration period, if any, of the company by the constitution expires, or the event, if any, occurs, and then on the occurrence of which the constitution provides that the company is to be dissolved, and the company in general meeting has passed resolution requiring the company to be wound up, or if the company so resolved by special resolution. So this is as far as voluntary winding up is concerned. Okay, and we're going to go into detail now. When is the commencement of the voluntary winding up? Section 441 provides the date. So voluntary winding up shall commence where a provisional liquidator has been appointed before the resolution for winding up has been passed, and then in any other case at the time of the passing of resolution for winding up, for voluntary winding up. So basically there are two types of resolution. This is governed by Section 439. First one is ordinary resolution. It is passed when the AOA, actually when the constitution provides that the company is to be wound up, when the specified purpose has been achieved or specified period has elapsed. Okay, and then special resolution, it requires no ground for winding up. Okay, and is issued in any other case, such as even when the company is solvent, so they wanted to wind up the company. So this is a solvent liquidation. Basically is by choice. Okay, can I just change here? Should be constitution. Okay, constitution. Okay, next one, what are the types of voluntary winding up? So this is governed by Section 432, subsection 2. There are two types of voluntary winding up. The first one is member voluntary winding up. This happens when the company is solvent. And the second one is creditor voluntary winding up when the company is insolvent. Okay, so member voluntary winding up happens or initiated by special resolution. You proceed when the company is solvent. So director make declaration to the effect that they have made inquiry into offence, and they are of the opinion that the company are able to pay their debts in full within 12 months after commencement of winding up. And there has been general meeting whereby they appoint liquidator to wind up the affairs and distributing the company asset. Okay, and then members have supervisory powers over the liquidator's conduct of liquidation because it's voluntary. So everything is done hopefully smoothly, right? So they try to close up properly. But now for a company, we don't actually call cease business. You cease your business, yes, but it's not like okay, we decided to close down our company and then that's it. But no, for companies you have to go through this process. Unfortunately, they call it winding up. So when you say it's winding up, it looks like they did not pay their debts, but this is voluntary winding up. Now the second type of winding up I said just now is creditor voluntary winding up. So this happens when the company is insolvent. Okay, meaning they are not able to pay. Okay, and this creditor's voluntary winding up only happens when the company is insolvent and those creditors have legitimate interest in the conduct of litigation, the Companies Act permits the creditor to appoint the liquidator. So basically, they also fix the liquidator's remuneration and supervise the liquidator's conduct. However, it cannot be initiated by the creditor. Although it is called creditor's voluntary wind up, okay, it can only be initiated by the company. The reason why they call it creditor, because the company is insolvent and the creditors have legitimate interests, okay, over the affairs of the company, particularly if they want the company to pay their fees, okay. So, a member voluntary winding up is converted into creditor's voluntary winding up, okay, the moment they find it is actually the company is insolvent. So, how can this happen? Okay, this can happen in two ways. Firstly, there was no declaration of solvency. So, when there's no declaration of solvency, chances are that actually the company is not solvent. So, that's why it actually converted. Or after appointment of liquidator by members, they find it the company is actually insolvent. Okay. Now, I'm not going to go into detail. This is the detail, yeah. Okay. And then, what will be the effect of voluntary winding up? Okay, the moment the company is wound up, the company shall cease to carry on business, except so far as in the opinion of the liquidator for the beneficial winding up thereof. So basically, the company would not continue their business unless they find it that maybe certain projects they still need to continue because there are probably some money dues, okay. And then any transfer of shares and any alteration of the status of the members made after the commencement of the winding up shall be void. Okay, so this is all about voluntary winding up. So now we are moving on to striking off. Okay, what is striking off? The process in which the registrar exercise his discretionary power to strike the name of a defunct company, from the register. Okay, if the registrar has reasonable cause to believe. Okay, there are so many belief here. So basically, first one, company is not in operation or is carrying on business under section 549. Okay, what is section 549? 549 talks about the company not able to carry on business, and then the company has contravened this act. And then next one, company is being used for unlawful purpose or any purpose prejudicial to or incompatible with peace, welfare, security, of public interest, public order, good order or morality. And then the company has been wound up but no liquidator is acting. Still, the registrar can just strike off from the register. And then liquidator failed to lodge a return and the liquidator's account of the wound up within the stipulated period. And then company has no asset or insufficient funds to pay the cost of obtaining an order from the court to dissolve the company. And then the company that has been struck off from register will be dissolved on the publication date of the notice of the register. Okay, and then under section 370 subsection 2 paragraph D, okay, provides for the reconstruction and amalgamation of companies regarding dissolution without winding up of the transferor's company. Okay, that is all about striking off, discretionary power of the registrar to strike out from the name from the register. Okay, the name. Okay, who is a liquidator? Liquidator is a person who help the process of winding up. He must be an approved liquidator, must not indebted to the company. or to a corporation related to the company, okay, in an amount exceeding 25,000, must not be an officer of company, must not be a partner, employer, okay, must not assign his estate for the benefit of his creditor or make arrangement with his creditor under any law related to bankruptcy. And this is one of the most important part. He must not be a bankrupt, and he must not be convicted of an offense involving fraud or dishonesty. Otherwise, there's no point of being a liquidator. Okay, so dishonesty here is punishable on conviction by imprisonment for 3 months or more. Okay, then pursuant to section 433, subsection 2, paragraph A and C shall not apply to members voluntary winding up or creditors voluntary winding up. Now, who is a liquidator? He is a fiduciary agent of the company. Okay, the property does not vest in him, but the company continue to exist. So actually, he takes up the duty of the director at that particular time. Okay, during the process of closing of everything, he takes the appointment of the directors, because the directors' duties functus upon appointment of a liquidator. Okay, and then what about appointment of liquidator in members voluntary winding up? So appointment done at the same time of the resolution. Okay, we have seen this. Okay, and then remuneration is fixed by the company during the meeting. And then what about declaration of solvency? Under section 433 provides where it is proposed to wind up a company voluntarily, the director, or in the case of a company having more than one director, the majority of directors may make a written declaration to the fact that the director have made inquiry into the affairs of the company, and they have are in the opinion of that the company is able to pay debts. So this is more of the voluntary winding up. Okay, and then last but not least, the general powers of a liquidator. Okay, what are the general powers? They can bring defense action or legal proceedings in the name or on behalf of the company, compromise any debt dues, okay, sell immovable and movable property, and do all acts to execute on behalf of the company. And then proof rank and claim. So proof rank here, the other one actually determine who should be in the ranking for the payment of the debts. And then what's the other one? Okay, draw, accept, make, endorse any bill, raise security, take out letters of administration, appoint agent, appoint advocate, okay, or do anything necessary for the winding up affairs of the company. So once liquidator appointed, like I said just now, power C. So they have a very big power here, especially when the liquidation comes in. Again, I would like to draw your attention to the definition of officer. Look back for the definition of officer under section 2 subsection 1, where officer also includes any liquidator of a company appointed in a voluntary winding up. Okay, so if it's a voluntary winding up, that particular liquidator is an officer of the company. Why? Because you appoint them to help you for winding up of your company. Okay, so that's all for winding up. Thank you very much. Having 14 weeks of classes with 3 weeks of classes face-to-face, and the other 11 weeks, I should say almost 11 weeks. Okay, I hope all of you have understood this topic. I'll see you during tutorial. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.